Video 257. The probate process. Explained what happens to an estate after death. Even with a will in hand, most estates go through probate, a court process that families rarely understand until they're suddenly in the middle of it, grieving and trying to figure out paperwork at the same time. Knowing the basics ahead of time makes an already hard season a little more manageable. What probate actually is. Probate is the legal process through which a court validates a will, if one exists, appoints someone, usually called an executor or personal representative, to manage the estate and oversees the process of paying debts and distributing remaining assets to heirs. If there's no will, the court instead follows your state's intestacy laws to determine who inherits, which may not match what the person would have actually wanted. Probate exists to protect creditors and heirs alike, but it comes with real costs in time and money. What actually goes through probate? Not everything a person owned ends up in probate. Assets with a named beneficiary, like life insurance policies, retirement accounts, and payable on death bank accounts, generally pass directly to that beneficiary, bypassing probate entirely. Property held in joint tenancy typically transfers automatically to the surviving owner. What's left, often the biggest and messiest pieces, is what goes through probate: individually owned real estate, personal property, and any account without a named beneficiary. This is exactly why keeping beneficiary designations current matters so much. The executor's actual job. If you've been named an executor or you're wondering what to expect from one, the role involves more than most people picture. An executor typically files the will with the probate court, notifies heirs and creditors, inventories and appraises estate assets, pays outstanding debts and final taxes from estate funds, and eventually distributes what remains according to the will or state law. It's a genuinely significant time commitment, often stretching across months, and executors are legally entitled to compensation for the work, usually set by state law as either a flat fee or a percentage of the estate, worth knowing if you're ever asked to serve in this role for someone else. How long it takes and what it costs. Simple estates can move through probate in a matter of months. Complicated ones, especially those with disputes among heirs or complex assets, can stretch on for a year or more. Costs vary by state, but typically include court filing fees, executor compensation, and often attorney fees, which can add up to a meaningful percentage of the estate's value in some states. This is a major reason many people work with an estate planning attorney during their lifetime to structure assets in ways that minimize what actually has to pass through probate. How to make it easier on your family. The single biggest thing you can do is keep your will current and your beneficiary designations up to date across every account. Consider whether a revocable living trust makes sense for your situation. Assets held in a properly funded trust generally avoid probate altogether. Some states also offer a simplified, faster, small estate probate process for estates below a certain dollar threshold, which is worth asking your attorney about if your estate is relatively modest. Keep an organized list of accounts, policies, and property, along with contact information for your attorney and financial advisor, somewhere your executor can actually find it. A little organization now can save your family months of confusion and unnecessary legal fees later. When a will gets contested. Occasionally, an heir challenges a will during probate, typically on grounds like claiming the deceased lacked mental capacity when signing, was subject to undue influence from another family member, or that the document wasn't properly witnessed. Contests are relatively uncommon but can significantly extend the probate timeline and drain estate funds through legal fees on both sides. The best protection against a future contest is having your will properly drafted and witnessed by an attorney while you're clearly of sound mind, and if you're concerned about a specific disgruntled heir, discussing your reasoning with your attorney so it can be documented at the time you sign. So, as we wrap up, here's the real takeaway. Probate isn't mysterious. It's a structured legal process that steps in when someone dies to validate the will, settle debts, and distribute what's left. Some assets bypass probate entirely, others don't, and the difference often comes down to whether beneficiary designations were kept up to date. A little preparation during your lifetime can spare your family months of confusion, stress, and unnecessary legal fees. Probate isn't something you control after you're gone. It's something you prepare for now, while you're clear-headed and able to make deliberate choices. Now here's your improved call to action. Take 20 minutes this week to review your will and every beneficiary designation on your accounts, bank accounts, retirement plans, life insurance, anything with a named beneficiary. Make sure they match your current wishes. If you've been considering a revocable living trust or haven't updated your documents in years, schedule time with an estate planning attorney. A small amount of organization now can spare your family a long, difficult probate process later. Thanks for spending this time with me today. If this helped you feel more prepared, feel free to join me for more videos like this. And remember, planning ahead isn't just practical, it's an act of care. I'll see you in the next one.